Good evening, this is John Milburn for Laws 11057. This is week 12 of term 2, 2019, our final week. Tomorrow I release the take-home paper. We'll talk about that tonight. We'll talk about some of the techniques that I think you need to employ in answering the problems correctly. First, let's look at the Moodle landing page as I describe it. And I particularly want to both thank you and encourage you collectively in relation to the have your say stats. So top left-hand corner, have your say. You'll see on my screen, and I'm not sure if it shows up on yours, but I can see that 26 out of 82 in the cohort have completed the feedback. Thank you to those who have. If you haven't, would you please do so now? It's very important for the university and particularly important for me that I get to 41. So I need another 15 responses as a minimum. I believe it doesn't take long. Those of you that have completed the task can correct me if I'm wrong, but it's certainly, it's anonymous and it's certainly very useful. So as for the take-home paper tomorrow that I will release, you'll see the assessment link is, for me, as always, in the left-hand corner. Assessment 3 briefing paper. I'll release it at about 6:30 p.m. Queensland time, and it's due Friday, 11 October, 11:45 p.m. Queensland time. So please make adjustments for daylight saving or whatever state or country you're in when you go to submit your work. Remember, of course, that the system will literally lock you out if you're late. So please ensure that you submit your work on time. Don't be afraid to submit a little early if you want to do that. Other than that, I'd recommend that you glance through all of Moodle again. Make sure that you've seen all of the Zoom sessions, and you've considered particularly the information guide for the take-home paper. Right. Any questions about that so far? All good? Any questions about the exam? All right. Do I take it that everyone has completed their pro forma, so their skeleton for the exam? So now it's a matter of inserting the detail. If you haven't, and you're looking for something to do to prepare for the exam, please prepare a nice pro forma. Just a quick chat, an opportunity for you to get the fingers working. Can you please tell me, when it comes to preparing the template, if you like, for answering this take-home paper tomorrow, what are some of the things that you've included in yours that you'd like to share that you think might help your fellow students? Headings, says Rachel. I like that. Assumptions, Chris, very good. That's an excellent particular heading. Ethics, very good, Glenn. You know that I'm very keen on ethics, so that's good. And I take it, Chris and Glenn, you're following on from Rachel's comment, where Rachel says, build into your template, your pro forma headings. So these may be some specific headings, or they might be prompts for yourself somewhere, but you certainly need to include them. You don't have to have a cover sheet, but you might consider it. Some unit coordinators require it. Some unit coordinators require you to provide a certificate that the work that you have generated is your own work, and that work of others that you directly quote, or at least that you rely upon their ideas generally, is footnote referenced. I don't require that certificate, but you can include it if you wish. Some unit coordinators require you to provide a word count. I don't require it. I'll do my independent checks on that, but include it if you wish. Some require you to include a cover sheet. I don't. You might, if you want to, include a cover sheet. Some people include a table of contents. This is all part of the pro forma. You don't have to. Particularly for longer papers, I think it's a very good idea to do that. And I'll talk a little bit more about some of the things that go to making up good writing tonight as well. So ensure that if you don't know how to footnote reference, and I'm sure you all do, it's so simple, but please do. Have people worked out what style they're going to use? Does everyone know what I mean by style in a Word document? Yes or no? Do you know what I mean by style or styles in Word document? If you don't, please do some research on it now. And you'll see the tab in the top ribbon, Styles. You can create your own styles. If you're going to, if the default in the program that you're using is, say, Calabria 11, and you like Arial 12, then my recommendation is that you actually change normal in the styles from Calabria 11 to Arial 12. That way, if you introduce something, it won't default to the old style. You don't have to manually change it to suit the style that you use. For me, I just go with what Word tells me. So Calabria 11 is what I adopt, but you don't have to do that. Generally, anything that you type would be in 11 or 12 font, and don't be afraid to make it 1.5 line spacing. Do leave space between paragraphs so that visually it's easy for me to read and visually it's appealing. All right, so all good on those basics. We should all know that. If you're having trouble with any content, then what you might consider is going to the student portal. We'll share that now. Hopefully I can find it. And is everyone familiar with this homepage, MyCQU? You'll find some very useful material, learning support, student services, research support, etc. So please familiarise yourself with that, and also other more specific things like plagiarism policies, etc. Tonight I'm going to borrow some material from what was a prescribed text in this unit some years ago, and it was a text called A Practical Guide to Legal Research by Milne and Tucker. Very good publication. It's still, I think, in print, or you may be able to pick up some of the older editions quite cheaply. So in A Practical Guide to Legal Research, the authors raise a few issues and provide some practical tips to legal problem solving. So let's go through some of those. The 5-step process. Number 1, analyse the problem by identifying the material facts. Number 2, identify the legal issues. Number 3, locate the rules that govern the legal issues. Number 4, interpret and analyse the results of your search. And number 5, apply the research results to the facts in support of arguments. We're using different words there, but that's very familiar, isn't it? That's pretty much IRAC, IRAC, or MIRAT. MIRAT is probably more accurate. So when you're preparing an answer to a legal problem, for example, the ones that you're going to be faced with tomorrow, then you should go through that form of analysis in some form or other. I suspect that many of you will slavishly follow a MIRAC type layout in your paper. You know that that's acceptable, but I'm not a great fan of it. I want you to apply that logic, but then it may be that you find trying to pigeonhole in that very prescribed fashion ruins the flow of the work for you and just doesn't work as a legal document or an advice, whatever it is that I'm asking you to prepare. So think about that type of legal logic, apply it generally, but don't necessarily apply it slavishly. And I hope that makes some sense to you. One of the problems with that type of analysis is that it doesn't include some very important things that Chris and Glenn have raised tonight, such as assumptions and ethics. That's not part of that list. So if you slavishly follow the list, you might miss some things as well. Remember, of course, that when you're referring to material, I would like to see you refer to the primary sources of law as your authority for legal propositions, for any reasoning, in priority to secondary sources of law. So it would be a mistake to refer to a textbook and from that simply quote on page 43 that, Section 10 of the Property Law Act. So don't quote the Property Law Act from the text, quote the Property Law Act from the Property Law Act. I hope that makes some sense. When you're looking to answer a legal problem, you need to consider it from a range of perspectives. And again, this is another reason why you probably don't want to slavishly follow the IRAC or MIRAC or CIRAC method, because you need to consider the statute or statutes, and you need to involve statutory interpretation principles in that, don't you? You need to consider case law, and you need to be able to analyse the case to extract from it that which is the most important part. Jade is a great resource in this, because if you look at a case in Jade Barnett, it will do a lot of the work for you, in that on the right-hand ribbon, it will specifically refer to that part of the decision that has been cited in other cases. It'll tell you the number of times it's cited. So if you're glancing down a case and you're trying to work out what's the most important part, if you're doing your analysis through Jade, it'll pretty much signpost it for you. You'll see that one court referred to this part, but 27 court decisions referred to the next one. So the next one is probably the key. So it gives you an idea. Whatever it is, whatever platform you use, you need to be able to analyze a case. And then, of course, you need to understand the relationship between the statute law and the case law. General principle, that which is in the statute will override that which is in the case, provided, of course, that the case is not a decision about how to interpret the statute. I hope that makes some sense. So we do see sometimes this revolving door situation where the courts make a decision in relation to a topic, Parliament doesn't like what the courts have done, introduces a statute, that statute then overrides the decision that was made by the court because the statute is regarded as superior in that regard. But then lawyers go to court in relation to the new statute and say, in relation to these facts, we think you should interpret section 10 this way. The opponent says, no, it should be that way. The court makes a decision, and therefore the court case applies because it is a means of interpreting the statute. I hope that makes sense. Remember, of course, that the question that you have before you may require you to consider jurisdictional questions. And the basic jurisdictional question is, are we talking about something that is state-based or something that is federal or Commonwealth-based? Because that will have a bearing on whether you go to the state laws or the Commonwealth laws. If, for example, and these are not necessarily hints, these are just examples. If you have a question in the exam on family law, then odds are you'll need to look at Commonwealth legislation, because the primary piece of legislation in relation to family law is the Family Law Act. And that's Commonwealth, isn't it? Do we all know that? Or do we have to look that up? It's okay if you have to look it up, but you need to have some way of identifying whether this problem is state-based or Commonwealth-based. It might be obvious, or it might be subtle, and it might be more difficult. Generally speaking, most would be state-based problems, but that's just a general statement. Then, of course, in addition to identifying the jurisdiction generally, you need to identify the law that applies to it. So are we talking about contract law, torts law, administrative law, consumer law, environmental law, criminal law, whatever it might be, and it might be a combination of them. So you may have to undertake some research and provide an answer that is more broad in scope than what it might first appear. You need to reference your material, of course. So please, if you haven't already got a ready reckoner for AGLC4, please have that ready to go. So we talked about the legal problem solving process. So for example, MIRAT, which is where you identify the material facts. The task there is to determine that which is important, relevant, as opposed to that which is superfluous. Now, if you ask Chris, he will say, yes, but you need to also consider whether you're making some assumptions when you look at the facts in the case. And if you find yourself making an assumption about the facts, then you should state that. If you're, conversely, if you think that there's something missing, you can make a statement that your response is subject to obtaining further information in relation to non-stated material facts that relate to this and that. I hope that makes sense. So when we talk about the material facts, it's not quite as straightforward as you might think. It's a matter of identifying that which is material as opposed to that which is superfluous, but also considering the assumptions that you might make and identifying the material facts that are not stated, that should be stated. So it may be a difficult task to actually determine the facts. You'd think it'd be easy, but not necessarily. You then need to consider the type of law. And when we consider the type of law, for example, negligence, we need to understand what a negligence claim entails. What does someone need to establish to be successful in a negligence claim? Well, the answer is, essentially, you need to identify a duty of care. This is negligence. Number one, is there a duty of care? Number two, has the particular party breached that duty? And number three, is there resulting damage? So having some quick reference guide to those elements, although the elements of the law in particular areas, would be a useful thing to do for preparation of your exam. Likewise, if we're dealing with a contract, what do you need for a contract? 5 things. I'll get you working on this. Some of you have probably anticipated that there might be a question on contract in the exam. So what are the 5 elements, aspects, requirements for the existence of a contract, generally speaking? That's a really good answer, Samara. That's an overriding thing. Samara says capacity. That's overriding, but it's not one of the 5 that I had in mind. But a good answer. So we're getting some answers coming in now. Rachel says offer and acceptance. Yes, I agree. Gary says offer, agreement. Not sure about that because the agreement is the contract. So the agreement is what we're trying to ascertain exists or not. It's not the element, if you like, if you know what I mean. Capacity, and I don't know what 12 CLR means. Sorry, Gary. Condition, says Rachel. Not necessarily one of the elements that I'm thinking of, but a good thought. Samara's got the third one that I'm after, consideration. So of the ones that have been suggested so far, I like offer, number 1. Number 2, acceptance. Number 3, consideration. Those of you that haven't studied contract law will say, what's consideration? We'll come back to that. Gary, I like number 4, an intention to create legal relations. And I can that was your code, wasn't it? Intention to create legal relations. I get it now. Thank you, Gary. Lucy says invitation to treat. Not quite. Good answer. I like the way that you're thinking about that. but that really relates to the offer aspect of it. It's not one of them. Chris says terms, which is similar to Rachel's response, conditions. So far we've got offer, acceptance, consideration, intention to be legally bound to the agreement. That's probably all we need. I'm saying 5, and I said 5, and now I'm thinking, oh, it's 4. So I need to brush up on that. Sorry. Completeness is another one that's said. So we need to have a clear statement of what's involved in the creation of a contract, and some of the things that were suggested are particularly relevant, but not one of the elements. So capacity, yep, make sure that you've got some clear statement of capacity. We know that's, you can look at the Guardianship and Administration Act. Invitation to treat is really not an offer, but it's an invitation for someone to consider making an offer. So when you, for example, walk into a shop and you see something that is advertised for sale, you might think that's an offer, but it's not. It's an invitation to treat. It's essentially saying, I'm here to do business. Here's what I suggest would be a good offer to make. How about you make me an offer? So if you say, well, yes, I like that car. The sticker price is $9,000. I'll offer you $8,000. Will you accept it? So the $9,000 was the invitation to treat. The $8,000 was the offer. And then, of course, it's a matter of the acceptance or not. So if someone advertised a car for sale and the price was $8,000 and you knew this car was worth $18,000 and you said, I will accept that offer at $8,000, and the salesperson says, oh, I'm sorry, hang on, the one has blown off in the wind. Let me stick the one back on. It should actually be $18,000. You can't argue successfully that the mere placing of the sticker, which then became a mistake, amounted to an offer. That was only an invitation to treat. I hope that makes sense. All right, so when we talk about consideration, that is the amount that's being paid, or conversely, the detriment that's being suffered. When we're talking about a car, the consideration is the amount that's paid for the value of the car. So it's, if you like, the exchange between the two. Right, so let's get back to MIRAT and the issue of how to put all this together. So when you look at the case, the problem that you need to answer, I guess you've got to list the facts, put them in some sort of order, particularly if it's a complex question. And it may be that the facts are not ordered chronologically, because when you take instructions from clients, they rarely say everything in a logical, straightforward manner. They're all over the place. So you've got to put it together in a form that makes sense. Usually that's a logical order or it's a chronological order. Then you've got to ensure the facts are complete. And if there are missing facts, acknowledge that and say, either I'm making an assumption or I can't answer the question completely because I don't know the full facts, or depending on the facts, here's what might happen. So what are some of the questions that you might ask yourself when it comes to answering a legal problem? Well, I guess the first is, what happened? Who's responsible for what happened? And then there's a lot of further W questions like, when did it happen? Where did it happen? Even why did it happen? So this is all part of the task of identifying the legal issues. And then there are these basic questions. For example, if it's a negligence question, does the person have the duty of care? Has it been breached? Has the other party suffered as a result, as I mentioned earlier? And the legal problems usually have more than one issue. So, for example, and there are side issues that might come into play. So a contract matter might relate to the law of contract, but it also may involve aspects of consumer law. So be aware of that issue. When you're undertaking your analysis of the rules, you'll always be considering legal reasoning. And remember, of course, when you're arguing a case or when you're providing a response to a question, it may be that there's simply no clear piece of legislation that deals with the problem, and there may be no clear case that deals with the factual situation precisely. So to some degree, you need to guess, don't you? And don't be afraid to say something to the effect of, there is no clear statement in the legislation or the case law, but if we look at this case, we can draw conclusions from it. And therefore, by analogy, we might argue that the particular problem that we have before us will be answered in this way. So that's where your reasoning by analogy comes in. So you're treating cases in the past as a means of likely predicting the outcome relative to the matter before you now. Or you might use inductive reasoning, which is part of your legal reasoning skills. So you're arguing from a specific precedent or principle to form a more general conclusion. Or it might be the other way, deductive reasoning, where you're arguing from a general principle or a precedent to move to a more specific conclusion. So you might even consider including some of these things almost as subheadings, or having them at least in the back of your mind. So you can use those terms. In practice, we don't. We might talk about comparable cases or a principle by analogy. We might, but we don't usually say, applying deductive reasoning, I think this will be the end result. But it's something you could consider. So when you're applying the law to the facts, you need to go through a few steps, don't you? You need to identify the statute or the case law, the precedent that provides the rule. And then if there's a number of cases, select the best case to illustrate or to apply the law in that case. Then think about, when you're looking at statutes, whether you need to apply some statutory interpretation principles. And don't be afraid to include this as part of your response, even if it's footnoted. So if, for example, you say, well, the principle that best serves this purpose is such and such, then have some authority for that. The go-to case usually in statutory interpretation is Project Blue Sky. So at least have that ready to go. You might use it once or maybe more times during the course of an answer. Ultimately, what you're looking to do is provide some sort of systematic and logical application of the law as it applies to the facts in the case and come to a conclusion. And sometimes, because it's not officially part of the IRAC method, people forget to mention a couple of things. We've already said assumptions and ethics, but people also forget what remedies would be available. So it's all very well to say, you know, as a result of these facts and this law, you can sue this person. That's fine, but can you go further? Can you say you can sue this person in this court or this tribunal? And can you go further again by saying you can sue this person in this court or in this tribunal and ask for this remedy? So what do we mean by remedy? I'll open it up. Get your fingers working again, or feel free to unmute the microphone. What do I mean by a remedy? So Gary's got some, Samara says, a solution. compensation as an example. Gary says injunction or decision. Lucy says compensation. Chris says apology. That's a good one. Yeah. So that's particularly relevant in, say, things like defamation or workplace issues, things of that nature. So what is it that you're seeking, essentially? Typically, if we're applying black letter law, it was damages. But if we're applying equitable principles, remedies included things like injunctions, declarations, specific performance, quantum merit claims, things of that nature. Samara says an order to get out of a contract. So we would seek, in that instance, a declaration, wouldn't we? We'd seek a declaration from the court that the contract is void or something to that effect. So do try to identify a particular remedy. And you'll see that from case law. So if you're looking to answer a question, you might look at previous cases. Just look and see what order the court made, and that'll give you a hint as to the likely remedy that you might seek in that instance. So that's all I propose to say about the process of legal thinking, logic, and problem-solving skills. Before I move on, and we do have some more tonight, before I move on, are there any questions? All good? All right. Writing well. You know that I want you to write well, and you know that I want you to do well. One of the units that I have the privilege of being able to take, and I'm taking it now, is a second year subject called Advanced Statutory Interpretation and Drafting. The drafting aspect gives me an opportunity to once again encourage people to write well. Not the way that I was taught to write when I first started in law, but to write in a way that is simple, direct, and understandable. Now, there are two articles that I referred to in particular in the context of writing well. I'm going to refer them to you now. They're not part of the reading. You don't need to read them, but this is just to give you an idea of what it is that I'm looking for in terms of what you produce. The first article is by Thomas Word, and it's called A Brief for Plain English in Wills and Trusts. It's an article from the US in 1980. I'll extract just a few things from it. Now, Thomas Word says, in the context of drafting wills, this: a will is the most personal of writing, save perhaps a love letter. I like that as an opening sentence. Very simple, very direct, quite short, but really interesting. He goes on to say, and yet, we respond to our clients' simply expressed wishes about who gets what with a bewildering instrument that is too wordy and redundant, flooded with lawyerisms, unfamiliar words, and inactive verbs. Number 2 and 3, poorly organised. A will should be written for the client's eyes. So when you're writing your exam question, be mindful of to whom the document is directed. Now, in the context of a will, Thomas Word says, the will must be technically sound, but it need not be written in legalese. By applying plain English principles in our wills, and indeed all our drafting, we respond to our clients in language they understand, and it will improve our instruments technically. So he gives an example of what's too wordy and redundant in the context of a will, and says, last will and testament of John Quincy Doe. I, John Quincy Doe, now residing in the city of Richmond, state of Virginia, being of sound mind and memory, do hereby make, publish, and declare this to be my last will and testament, hereby revoking, annulling, and cancelling all of my wills and codicils heretofore made by me. Now that's kind of a lot of words to say something, but that's exactly the sort of thing that we were encouraged to write when I first came into the law. It's not that long ago. That was 49 words, what I just read. Instead, why not say, I, John Quincy Doe of Richmond, Virginia, make this will and revoke earlier wills and codicils. It says the same thing, 17 words. Thomas' word goes on just to explain some of the history as to why lawyers write this way. And I thought this was excellent, interesting to know why we've written this way. Some people said it was because we were paid by the words, number of words we wrote. And to some degree, there's some validity in that, because in the old days, particularly, less so now, but we were paid per folio. So the more words that you wrote, the more pay you got. But really, the true reason is the reason we had these different words, it's based in history. At various times, the English had two languages from which to choose. Originally, the Celts or the Anglo-Saxons. Later, the choice was English or Latin. And then still later, it was English or French. So lawyers began to use a word from each of the tongues joined together for a single meaning. And that created this legal tautology syndrome. So we hear these phrases like free and clear in the context of title. So the frio comes from English and French is from clair. Other terms like full and complete, good and sufficient, that's because of that historical bent. There's another article, Duke MacDonald, 10 Worst Faults in Drafting Contracts. So the first is don't use legalese. Second is write in the active voice rather than the passive voice. The third is don't agree too much. And I say that in the context of drafting documents, people would start by saying, it is hereby agreed and acknowledged that number one, it is agreed. Number two, it is expressly agreed. Number three, and it became lots and lots of clutter. Don't use a cesspool of words. Try to keep things simple if you can. Group sentences in like fashion. If you have a new idea, start a new paragraph. Do try to structure your sentences correctly and make sure that you write plainly. All right, so that's all that I propose to say about the way in which you write your material. Any questions there? Good. Information about grades. When it comes to grading assessment work, if you make 50% for the entire unit, then you pass. If you make 65%, then you get a credit. If you get 75%, you get a distinction. 85%, you earn yourself a high distinction. The first 50% of marks are much easier to obtain than the last 50%. The hardest marks always to obtain are the last 20%. That's where it gets really tough. When I mark the final papers, I will generally advise students of the average grade across the board, and I will provide some general comments, but for the take-home paper, unlike the first two assessments, I will not provide you with personalised feedback. That's a university policy. You'll see that in all of the units, I think, that you take. When preparing for the take-home exam, you might consider some content. For example, the video that I've prepared, the sample paper that I've prepared. There's some excellent resources online, such as How to Study For and Take Open Book Exams by Elizabeth London. This was from April this year. So that's from the collegeinfogeek.com Open Book Exam. So that's a nice, easy way to assist you in the preparation for your exam. When you're preparing for the exam, you'll really need to have your legal research skills ready to go. That would be second to do after you've prepared your template. So you've prepared your template, then you've got, and probably this should be your toolkit really, you've got your strategies in mind for your legal research, and you need to have a good understanding of the difference between common law and equity. So it may be that the question requires you to provide some commentary about common law remedies or equitable remedies, and we've talked about some of that even tonight. You need to understand the federal and state relations and the sources of the law, which we've talked about, legal research, legal thinking, communication and drafting. All right, I'm just looking at my checklist and I think we've covered all of those things. You've all had a look at my video on how to prepare for take-home papers. I take it yes. If you haven't, please do so. So you'll understand that I want you to be working to level 3 standard here so that you're ready to go. When it comes to writing your work, I'm going to now refer to some material that comes from the Great Guide to University Study. Topic 5, developing academic writing skills. So let me race through these. I say that respectfully, but I'm conscious of the time. Number 1, academic writing requires the use of more formal language than in everyday speech. So please, no slang, no contractions, for example, shouldn't or won't, type should not or will not, no text message speak, no emotive language. That said, you can be creative. If you think that a flowchart or a table best describes what it is that you wish to say, then use that. So you can still be creative. For me, generally, my eye is such that I like conservative but very professional looking documents. Don't have to be boring documents, but by the same token, if I look at the paper and it's shouting and there's lots of blinking lights and headings and different coloured fonts, etc., I personally find that distracting. Other people say that's more interesting, but for me, some sort of professional conservative approach to writing to the presentation. The next thing is from the Great Guide to University Study. Before you begin composing your response to a task, it's important you take time to analyse the question, topic, or ask what you are addressing. Next, a good set of notes will help you through that which you're required to work. Make sure that you avoid plagiarism. Next, write using complete sentences. So I do require to write in sentences and precise language. So when we talk about a sentence, well, the basic thing is the sentence needs to have a subject and it needs to have a verb. It can still be short, but you need to have it as a sentence. If you're really keen to ensure your work is of high standard, you might consider reading it out aloud or running it through some sort of proofing mechanism. Spell checks, grammar checks, etc. are really important. You need to analyse the material, and in doing so, that means pointing out points of similarity or points of differences, things that are missing, assumptions that you make, as we've discussed. Avoid long-winded, wandering answers. But at the same time, whilst I value brevity, I must confess I'm not a fan of dot point summaries. There is a place, I think, for tables and graphs and things of that nature as I've described it. But dot point summaries, for me at least, are things that I gloss over. So do try to avoid that if possible. And when it comes to answering questions with a tight word count, please don't waste words. So, for example, don't repeat the question. I know what the question is, so don't repeat the question. Having said that, it is very useful in a problem-solving context and necessary to identify the material facts. So you may find yourself drawing upon the content of the question, but you wouldn't reproduce the question in total. I hope that makes sense. Write professionally, watch your grammar, spelling and punctuation. And proofread the work before you put it in. Now, that is all that I propose to talk about tonight. And indeed, because it's week 12, that is all I propose to talk about in this unit completely. So we've reached the stage where all of the things that you've studied, all your hard work for the last 12 weeks, we get to examine when I release the paper. You can expect when you see the paper not to have a clue as to the answers. I can tell you that the questions that I write are not sourced from your textbook. I'm sorry. I think many of you know that I receive daily updates of court decisions. They come into my inbox. And of course, when I look at them, I think that might be a good question for environmental law or for torts law or for introduction to law. So many of the questions that I write are sourced from recent cases. So sometimes if you're lucky, you might find when doing your research that you find a case that looks very much like the question that I've asked you, and it might be that that's the case that I drew the question from. So that's one source. Another source is articles and newspaper things that occur to me. I hear something on the news, and I think, well, that might be an interesting question. So there's no necessary logic to it. These are just places where I find inspiration, for want of a better term, for the questions that I write. So don't think necessarily that there is a right answer, a single right answer. There isn't, because I'm working on these questions based on what I see around me. You might think that a case that draws on, from which I draw a question might be the right answer, but not necessarily, because quite often I might draw some material from that case and then other material from another case. So it really warps the answer completely. All right. Sorry I've talked so much. Before we wrap up, any questions, comments? All good? All right. Well, good luck tomorrow. If you have any questions, please feel free to ask, and I hope everything goes well. I'm sure it will, and I really do want you to go well. Okay, all the best, and we'll see you soon. Bye then.